Thank you. I'll give the floor to Honorable Patrick Obama.
Thank you very much, Chair, and congratulations to Sir Dennis Adjei. And to your big CV, fat CV, page 18, sir. I'm going straight to the church and to the Catholic Church, of which you are very respected and knighted. I'm seeing the names of Archbishop Peter Kwesi-Sapor. I've seen Father Campbell behind you. And I want to ask you, sir, the Catholic Church has a position on gay and lesbian rights. And you know, our laws also frowns on those practices. Definitely, you've heard some of the debates and arguments on some of these things. And there hasn't been any definite pronouncements by the Supreme Court. I'm not asking for your opinion should this matter come to you, but how would you marry this issue when it comes before you? Thank you.
Thank you, Honorable Chair. Honorable Chair, we talk about our faith, it could be Christian faith, Muslim faith, it is your faith. Then when you are in the courtroom, you have taken judicial oath. That I shall not be impartial, irrespective of the persons involved. So once you put on your judicial cap, you must bear in mind that you must perform in accordance with the judicial oath that you have taken. So to me, if any matter is brought before me, whether it is same-sex, whether it is whatever, when it comes before me, I will look at the circumstances, the law, and I will give effect to the position of the law, without being influenced by my faith. Otherwise, I will abdicate my seat as a judge. The African court is worse. You know, African court, we handle only human rights cases. These are some of the cases that come before us, but when they come, we handle. We don't put on our faith, because if we put on our faith, then a time may come. Every religious sect would insist that I should have a judge on this panel. Otherwise, if a case comes, I will not get what I want. But that should not be the position. Thank you, Honorable Chair.
Thank you, Chair. I don't have a follow-up question on that, but your CV said then it's nothing about sports. It's all about academic work, and book. My Lord,
what is the meaning of book and Kwan? At least for the record.
Just a scholar throughout his life, and must commend the gentleman from Adjei. My Lord, you've had extensive experience in judicial education. As a former Dean of Gimpa Law, Director of the Judicial Training Institute, and currently on the international judicial bodies, including ICC Advisory Committee, the African Court on Human and People's Rights. How would you leverage this experience to strengthen judicial independence in Ghana? And what reforms will you propose for continuous judicial education to ensure that our judges remain current with evolving legal principles whilst maintaining their independence from external pressures? Thank you.
Thank you, Honorable Chair. Honorable Chair, first and foremost, I will refer to our Code of Conduct. Our Code of Conduct talks about impartiality, independence, conflict of interest. So if you are a judge, once you take the oath, then you are bound by the judges, the Code of Conduct for judges and magistrates of Ghana. And you get all these things from it. We need to continue educating our judges and magistrates. That is the first one. Then the second one, we have the Bangalore principles of ethics. And we teach It is an international principle that whether you are a national judge, international judge, you must know. Because it will tell you that once you are a judge, you must identify yourself as a judge, and always have in mind that the executive and the legislature should not have any influence on you. And we even go ahead, apart from institutional influence, we also go ahead to talk about individual independence. If you are a judge and you are sitting on a matter, if you allow any person to influence your conduct, that means you have lost your individual independence to sit. So, Chair, what I would say is that, well, by God's grace, I have acquired international experience from the International Criminal Court. And when I mentioned the chairperson for the African Judicial Network of Environmental Law, it was all the judicial trainers in Africa. When we met, I was elected the president. That is what it means. And I go to other countries to teach, to train them. Even Tanzania some time ago invited me to help them draft their bench books. I've been in Sierra Leone. I've been in several countries. So I believe that with the cooperation of the authorities, we'll be able to train our judges. We retrain to the extent that their capacities will be built, and they'll be able to resist every attempt by either the executive or any other agency from encroaching onto their territory in terms of the exercise of their judicial power. Thank you.
Thank you, and I don't have a follow-up question on this, but let me go around this question. A lot of people have asked questions about the jurisdiction of the Supreme Court. We have about 7 or so. And I know sitting on the Court of Appeal, a lot of interlocutory appeals comes to you. From there, they'll go to the Supreme Court. If the substantive matter will not be dealt with, and the public will always be complaining about it. Given the opportunity to sit on the highest court, which of these jurisdictions that the Supreme Court is closed with, would you propose some reforms so that some of the matters are terminated, maybe at the High Court level, Court of Appeal levels, to also help in the reduction of the workload on the Supreme Court? And on that, Sir Dennis, I wish you the very best, and God bless you. Thank you.
Thank you, Honorable Chair.
Yes, my Lord Nominee.
Honorable Chair, if you talk about the jurisdiction of the Supreme Court in Ghana, let me start with the first one, the supervisory jurisdiction. The whole world, Ghana was the first country to give supervisory jurisdiction to the Supreme Court. Sierra Leone was number 2, and Philippines number 3. Throughout the world, these are the only 3 countries where Supreme Court exercises supervisory powers. If you go to UK, you go to all other countries, it is exercised by the High Court over the lower court. Because you call a court a superior court, then you are still supervising it. You know, Ghana introduced it through the 1969 Constitution. And if you look at the cases before the Supreme Court, about 40% of them are on supervisory jurisdiction. And you know, it is very broad. It is not limited to those coming from only Court of Appeal, High Court, Regional Tribunal. You can even go from a district court, for example, where a district court is interpreting Constitution. High Court cannot say that I am supervising you, because the High Court itself has also been restrained from delving into that matter. So any area that the High Court lacks jurisdiction in, and any of the lower courts purpose to do, you have to go to the Supreme Court. So now, if you go by the supervisory jurisdiction, I believe it will be okay. But the Supreme Court introduced another limb to it, interest of justice. Because we all know that wherever you go throughout the world, supervisory jurisdiction they have faced. We talk about natural justice, we talk about patent error on the face of the record, we talk about breach of the Wensbury principles, then we talk about jurisdiction. But Ghana, we have added interest of justice. And because of that interest of justice, any freezy case, somebody will go to the Supreme Court. You will dismiss, but the person has wasted time. So that is one thing. Then when we come to Article 131, appeals. Appeals to there's a problem. Appeals, we are saying that High Court, Court of Appeal, if the case starts from the High Court or Regional Tribunal, and you come to the Court of Appeal, as of right to the Supreme Court. Then, irrespective of where it starts, if the Supreme Court decides to give special leave, they will give special leave. Then the other one, when we talk about the lower court, any person who loses at the Court of Appeal, you need leave to go to the Supreme Court. So the leave and the special leaves, I believe you can do something about them. If we take away even special leave alone, then some of them, as is done in some jurisdictions, some of them terminate at the Court of Appeal, then Supreme Court will not be inundated with all these cases. And Honorable, apart from the jurisdictions that you have said, you know, apart from those Supreme Court, apart from those the Constitution has given, the Court Act has also given 2 additional jurisdictions to the Supreme Court. The first one, Section 9 of the Court Act, that when we are talking about prerogative of mercy, where it's not the one in the Constitution, this one where somebody petitions the President that, please have mercy on me. This one, then when it is sent to the President may refer to the Supreme Court to hear it as an appeal or may give an advisory opinion. Then we talk about Section 100 of the Courts Act, reservation of question of law, where Court of Appeal is hearing a matter and the Court of Appeal is confronted with difficulties. Then they reserve the question to the Supreme Court to answer for them. And Supreme Court will answer before it comes back. So these are some of the jurisdictions that we can do away with. Otherwise, Supreme Court will continue to be inundated with cases. Thank you, Honorable Chair.
Thank you very much. Before I proceed to give the floor to Adjei Ladi, Justice Sir Dennis, we know your background as a lecturer, so we'll plead that you are brief. We have one more judge to take. Yes. So, Adjei, you have the floor.
Thank you, Chairman. Congratulations, my brother. With all intents and purposes, I just want you to explain and tell me how you would agree with the mandatory imposition of death sentence when people violate the law. Do you agree with it? Do you not agree with it? In fact, I wouldn't want the answer to be too detailed. Just.
I agree that the mandatory imposition of death sentence is wrong. If a person goes to court and the person is to be convicted to suffer death, first and foremost, we must respect life. So we must give discretion to the judge who heard the matter, either the judge to give a number of years or to impose death sentence. But if you look at the treason, high treason, and the one in the Armed Forces Act 105, once you convict the person, then mandatory imposition of death sentence. And Ghana is a signatory to the African Charter on Human and People's Rights. And Article 4 of the African Charter on Human and People's Rights provides that you must respect life. And the African Court has variously held that any decision by any country not give a judge discretion in the imposition of death sentence is in violation of Article 4 of the African Charter. Ghana is a signatory. That is why I am there as a judge. And we have found several of them against Tanzania. Tanzania is the worst offender. Then we have found some of them too against Benin. So if cases from Ghana happen to be there, we are going to face the same fate. We are going to lose. Thank you.
Thank you very much.
Chairman, a follow-up on your response. I'm happy to have heard from you that we are a signatory and that you are even a member who can come up against those rulings. Will you suggest you have a committee of parliament, and even you yourselves are persons, you have individuals who can make inputs to parliament that we need to adhere to what the signatory we have appended, and that we must go by the law. I don't agree with the issue of the death penalty. In person, that is me. So I think I want to know from you whether you would want to take it up and that we should re-look at it.
So, my Lord, this question demands yes or no answer.
Yes. Honorable Chair, what I would say is that yes, we need to outlaw those things. And I was invited by Parliament to address them in Koforidua on this issue. And I came here to present a paper. Thank you.
Honorable Adjei Ladi, any further question?
No, please. Thank you.
Well, I'll then give the floor to Jerry Shai Ahmed.
My Lord, congratulations to you. My Lord, Chairman, if, with your permission, I want to place my question on the independence of the judiciary. So, reference is made to Article 125(1), that says that justice emanates from the people and shall be administered in the name of the Republic by the judiciary. We shall be independent and subject only to this Constitution. I want to situate this with 1466. In your view, do you think the judiciary is really independent?
Yes, Honorable Nominee.
Thank you. The first thing is that when we talk about the independence of the judiciary, the first thing that comes to mind is the exercise of judicial power. Because the Constitution itself, 125, says that not executive or legislature shall have final judicial power. So when we talk about the independence, the first premise is on the exercise of judicial power by the court. Then when it comes to 146, it comes to removal of judges. Removal of judges. If you look at it, it has provided that a petition, if it is against me, a petition shall be sent to the president. President shall forward to the Chief Justice. The Chief Justice shall make a prima facie case. So here, the question is, will that amount to encroachment on my core duty as a judge? And the answer is no. It will not impact on my core duty as a judge. But the only fear is that but for the judges, it is the Chief Justice who will set up the committee, then he takes other members from elsewhere, then they fall. And once they are certain as administrative bodies, then the law is that they are not supposed to go wrong. They must be fair and candid. Because if you look at Article 23 of the Constitution, any person discharging administrative function shall act fairly and reasonably within the law. So once you go off the law, then that means you are doing your own thing. So, well, there's likelihood that it may be compromised. There's likelihood we are human beings. But if we take into consideration by the fact that, yes, I'm a judge, I'm sitting on this matter, and this is my role as a judge, then at the end of the day, it should be based on the evidence adduced and the available laws that you must apply, and not your own opinions. Thank you.
You have any further question?
Yes, follow-up. Thank you very much, my Lord. My Lord, so if we come on the same 146 and the responses, you've given, would you think that the president having the powers to appoint and disappoint impacts on the independence of the judiciary?
The president has the, on the advice of the Judicial Council in consultation with the Council of State and prior approval of Parliament. So it is not him alone. So if the person is appointed, then when it comes to removal, the Constitution has provided for a particular procedure. And that particular procedure, it must be followed to the letter. Otherwise, it will amount to usurping the provisions of the Constitution. So once it is followed to the letter and a finding is made, we look at who are those sitting on the matter. Are they judges? Are they independent? That is the most important thing. So if they are independent-minded people, and at the end of the day, any decision that they take is premised on the evidence, I will not have any problem with it. But if at the end of the day, the decision taken is premised on any other extraneous matters, that is where I will have an issue. Thank you.
Any other question?
That's so. Thank you very much, Mr. Chair. Honorable nominee, what would you say about 1252, where citizens may exercise popular participation in the administrative of justice through the institution of public and customary tribunals and the jury and assessor systems? And this is against the background that some of us have seen that some assessors or jurors have occasionally or largely been the ones nominated to sit on a matter. And they have been consistent. So in about 15 to 20 years ago, I knew some particular workers from AMA who were always part of the system. Would you say that this is a system you'd want to have a relook at policy-wise and advise, or you think that it's a system that has to be maintained?
Thank you, Honorable Chair. Honorable Chair, I have a thesis on the role of the jurors. And I talk about, I made proper investigations. For instance, we must know qualification, who qualifies. You must be 25, then under 60. Then you must be literate in English. I went to some of the areas to make investigation. Some of them could not even speak English. Then I went to some of the institutions to make inquiries. They would tell me, oh, this man is troublesome. We have sent him over there. We don't have any other person to go there. You know, we do not understand the jury system very well. Because the jury system, it is your role to your nation building. And it is peer hearing. So we want to say that there is a matter which is a very serious matter. And therefore, we want your own people to come out to say that you are guilty or you are not guilty. That is the essence of the jury trial. But if you look at the position in Ghana now, some of them are becoming professional. If you say it, they become annoyed. When I was the regional bar president for Ashanti region, I made a pronouncement and they decided to boycott because of me. When I said that some of them will become professionals and we should not entertain, we should make sure that when you come maximum 2 years, you must leave. Then at a point in time, even they met and appointed somebody and called the person a dean. And I said, you could not call somebody a dean because it is not an office. So we need to refine it. We need to refine it because we don't appreciate the essence of jury system. If you are a judge, you may do the summing up and you may think that they may either convict or acquit. Then they will come with a decision that you never anticipated. You know, at times, you look at it, and if the matter comes on appeal, at times they have acquitted the person, or they have convicted the person, and the matter comes on appeal, and you look at it, there was no justification for the decision taken by the jurors, but it has been taken. But Ghana, the only advantage we have is that we can appeal against the summing up, unlike other jurisdictions where decisions by jurors are final and not appealable. So still, I would say that we need to reform it because as it is now, it doesn't help. Thank you.
Any question?
Yes.
Your last question?
Yes. No, this is a follow-up on the jury bit. It's not my last question. Apart from the suggestions you have made, is it the case that we should still have the jury system?
Thank you. We may continue to have it because it talks about citizens participation, for them to understand the role of the judges, the role of the citizenry. Because once you become a juror, we call you a judge of facts. So you are a judge, except that you are going to determine on questions of facts. So it helps people to even appreciate the legal system. So when something happens on the street, they will not take the law into their own hands and delve into instant justice. That is the essence of part of jury system. But if you look at the African continent, most of them do not have jury system. Nigeria abolished it through coup d'etat in the 60s. They don't have. Cote d'Ivoire hasn't got. Most of them do not have. So if an empirical evidence may be obtained and we see that it has outlived its relevance, we can outlaw it. Even though ADR was not specifically mentioned, we have positioned ADR under Article 125(2). That is why alternative dispute resolution, we get people who are not judges. We have mediators, conciliators, customary arbitrators. All of them come in to help. That is the rationale. Thank you.
Now your last question.
Yes, thank you very much. So my last question, Chairman, with your permission, Article 15(1) says that the dignity of all persons shall be inviolable. I want to look at 15(1)(b). That says that any other condition that detracts or is likely to detract from its dignity and worth as a human being. And I'm placing this with reference to, I'm situating it with reference to where a suspect now gets some details published by the prosecution, and in a very open manner, maybe through a press conference, and the person gets tortured and gets very demeaned. I do not know if you would have a take, you have any advice. Would you think that is the way to go in criminal jurisprudence? Thank you.
Thank you, Honorable Chair. Honorable Chair, what amounts to human dignity, degrading, inhuman treatment, they have been discussed in all the international instruments, particularly the African Court. I can cite about 20 cases. One of them is about where you use a cane, corporal punishment, Kabalabala versus Tanzania. It has been held that if you use a corporal punishment, cane, to whip somebody, you subject the person to inhuman or degrading treatment. Then torture, when somebody is alleged to have committed an offense, you assault the person, you will not give the person food, the person is hungry and thirsty, and you ask the person to give statement. It is inhuman. Then we have also held that if you impose death sentence on somebody and you prescribe that either to be killed by hanging, to be killed by a gun, to be killed by lethal injection, all of them, they are inhuman. Why do you say that a human being should be killed, a human being should be hanged? So if you look at our Article 15, it is from Article 4 of the African Charter on Human and People's Rights, verbatim. So the essence is that every accused person must be presumed to be innocent until either he pleads guilty or the court proves the person guilty. Until that one, then the person should be innocent and the person should not be subjected to any inhuman, degrading, torture, or any barbaric conduct. Thank you, Honorable Chair.
Yes, a supplementary question?
Yes.
Very well.
So, my Lord, so where we have instances of a press conference intimating that someone has virtually stolen or has virtually committed an offense or omission, I was requesting from your Lordship, especially, whether your Lordship would advise if that is the way to go or that is not the way to go.
the person is innocent. Whether you saw the person committing the crime or not, he's innocent because he has not pleaded guilty and the court has not convicted that person. So to me, to say that this person has been convicted, because the person has not been convicted, that is why in criminal law, we pass through stages. We pass through suspects. You are suspected. Then you are accused. Then you are charged before the court. If you are charged before the court and you go through the trial and you are convicted, then you become a convict. So convicts' rights are different from suspect rights, and they're also different from accused person's rights. So you may say that the person is alleged to have done A, B, C, D, but you cannot conclusively say that the person has done it because there is no conviction to that effect. Thank you.
Thank you very much,
So I'll proceed to give the floor
Chairman.
to
Thank you.
Honorable Bede Awantanzuma Zidi.
Thank you very much, Mr. Chairman. On a lighter note, Mr. Chairman, I want to congratulate my Lord, Sir Dennis. But I'm curious. Since I have known you, I have not known you to have Dominic as part of your name. So I'm curious. I've always known you as Dennis, and I know you to be Catholic. We worship together. When I saw your CV, I saw Dominic. How come you have got two Christian names, Dennis and Dominic? I'm interested.
Is that your question?
I said, oh, on a lighter note.
Why on a lighter note? Is there any law that prevents a person from having two Christian names?
Yes. Come again.
Is there any law that prevents a person from having two or three Christian names?
I just say that I'm curious.
Very well. Yes. Proceed to ask your question.
Yes.
Thank you, Honorable Chair. Catholics, we look up to the saints to imitate them. So at birth, I was given the Christian name Dennis Dominic. So I came to meet it. It wasn't that I took it. And I love the two names. Thank you. Because they have significance in the Catholic Church. Thank you.
Well, I'll treat that as question number one. Go ahead and ask the second question.
Mr. Chairman, I told you that it's on a lighter note. Anyway, I've come to my main question.
Ask the second question.
My Lord, we have had some challenges. We have had some challenges here in Parliament in dealing with the doctrine of separation of powers. I want you to give us some, if you like, since you have been lecturing, a little lecture of the doctrine of separation of powers in the context of the Constitution of Ghana, and in particular,